Number 1. Baltimore, 2016. An elite 8-man plainclothes unit is working the streets. They move fast, accelerate toward a corner, scatter whoever's standing there, and chase down whoever runs. It looks like aggressive policing. The department thinks it looks like results. The unit has press clippings, commendations, a photo spread in an official police newsletter. Sergeant Wayne Jenkins is standing in the center of that photo, surrounded by his detectives, grinning. What nobody in that newsletter knows is that the Drug Enforcement Administration is already running a wiretap on a separate Baltimore drug network, and the names they keep hearing on those calls don't belong to dealers. They belong to the cops. Jenkins joined the Baltimore Police Department in 2003. He built a reputation fast, aggressive, relentless, the kind of officer who could pull guns off the street before anyone else knew they were there. By 2016, he was heading the Gun Trace Task Force, an elite, plainclothes unit created specifically to remove illegal firearms from Baltimore's most violent neighborhoods. On paper, the GTTF was exactly what the city needed. In practice, Jenkins had turned it into something else entirely. The unit operated with almost no oversight. Plainclothes officers rarely logged their movements in detail. Nobody was checking the timesheets. Nobody was counting the cash. Jenkins and his crew, Detectives Herschel, Rayam, Gondo, Taylor, Ward, Hendricks, and Allers, had discovered that working a plainclothes unit in one of America's most violent cities gave them something almost no other criminals had, a badge that made every crime invisible. The scheme was methodical. Jenkins used illegal GPS trackers placed on drug dealers' vehicles without warrants to monitor their movements. When the timing was right, the unit would pull them over, conduct an unlawful search, and take whatever cash or drugs they found, then log nothing. The dealers weren't going to call the police. The unit knew that. What they didn't account for was that the DEA was already listening to those same dealers, and the names coming up on their intercepts weren't who anyone expected. Then there was the overtime. Records later showed the GTTF was submitting timesheets for hours they were never working. Hours spent, investigators later found, committing robberies. Some officers had nearly doubled their official salaries through fraud alone. The Internal Affairs Division had flagged Jenkins before. In 2014, a complaint alleged he had planted drugs during a traffic stop. A departmental board reviewed the case. One board member later admitted he had voted to acquit partly out of fear for his own career. Jenkins walked. The investigation went nowhere, and he took that result as confirmation that nothing would touch him. On January 2, 2014, the same year Internal Affairs cleared him, Detective Herschel and other unit members burst into the home of a man named Keon Paler. They stole his money. Then they walked outside and placed a handgun on his front porch. Paler was arrested. Facing charges for a weapon he had never touched, with no reason to believe anyone would take his word over a police detective's, he pleaded guilty to felony firearm possession. He was sentenced to 5 years. What Herschel and the others didn't account for. From jail, Paler made phone calls, recorded calls. In those calls, he described exactly what happened that morning. That he had been framed, that the gun wasn't his, that the officers had planted it. The FBI would hear those calls later. They became part of the case file. By early 2016, the DEA's separate wiretap investigation had handed federal agents something they hadn't been looking for. GTTF officers were not just taking protection money. They were robbing dealers, keeping seized drugs, and selling them. The FBI joined the investigation. A cooperating witness agreed to wear a wire. The conversations recorded over the following months removed any possible defense. Investigators later found cash in Jenkins' home, stuffed, according to court records, in locations consistent with hiding it from official scrutiny. The unit had robbed one individual of approximately $200,000 in cash found during an illegal search. Jenkins took it and never reported a dollar. The GPS devices were seized. The overtime records were pulled. Paler's jail calls were matched against the physical evidence from his case. The DEA wiretap intercepts, the FBI informant recordings, and the financial trail all pointed to the same conclusion. The Gun Trace Task Force was not an anti-crime unit that had gone wrong. It was a criminal enterprise that had used police authority as its operating framework from the beginning. On March 1, 2017, all 8 officers were summoned to internal affairs. All 8 were arrested on federal racketeering charges the same morning. The trial and plea proceedings played out across 2017 and 2018. 6 of the 8 pleaded guilty. Herschel and Taylor went to trial. On February 12, 2018, both were convicted by a jury. Sentencing followed. 7 years for the lower-end defendants, 25 years for Jenkins. He is currently serving that sentence at a federal medical facility in Kentucky, with a scheduled release date of 2037. Sergeant Keith Gladstone, a separate BPD officer who had helped Jenkins plant a BB gun at a different arrest scene, pleaded guilty to conspiracy to deprive civil rights and received 21 months in federal prison. The city of Baltimore reviewed thousands of cases connected to GTTF officers. It paid an $8 million settlement to 2 men who had been wrongfully imprisoned based on evidence the unit fabricated. Keon Paler's conviction was vacated. He filed a federal civil rights lawsuit. He had served 5 years for a gun that was placed on his porch by the detectives who arrested him. 8 men, a police newsletter photo, commendations on the wall and cash in the mattress. Convicted of running a criminal enterprise inside an anti-crime unit. Number 2, Los Angeles. An officer gets arrested for stealing cocaine from the police property room. He takes a plea deal, and then for 9 months he talks, implicating 70 fellow officers, describing a unit that operated like its own street gang, and describing the night he and his partner shot a 19-year-old in an apartment building, left him paralyzed from the waist down, and placed a gun on his unconscious body. Number 2, Los Angeles, October 12, 1996. Officers Rafael Perez and Nino Durden are inside an apartment building in the Pico Union neighborhood, using a unit on one of the upper floors as an observation post. They are watching for drug activity on the street below. That's the official version. The version that holds up in court for nearly 3 years. 19-year-old Javier Ovando is in the hallway. Seconds later, he is on the floor. 4 bullets in him, paralyzed from the waist down permanently for the rest of his life. The officers radio it in as a good shoot. Ovando charged at them, they say. He had a weapon. They acted in self-defense. By the time backup arrives, there is a Tech 22 semi-automatic pistol near Ovando's body. He is bleeding heavily, unable to move, unable to speak clearly. He has no criminal record. He is a member of the 18th Street Gang, and in 1996, in that neighborhood, that is enough. The jury believes the officers. The judge sentences Ovando to 23 years and 4 months, noting that he showed no remorse for his premeditated crime. He is taken from the hospital to prison in a wheelchair. What the jury didn't know, what no one outside the Rampart Division knew, was that the weapon near Ovando's body had been carried to that hallway in a red rag by Nino Durden. The serial numbers had been filed off. The gun had been recovered during a prior street sweep and kept. It had nothing to do with Javier Ovando. To understand how that was possible, you have to understand what crash was. The Community Resources Against Street Hoodlums Unit was the LAPD's elite anti-gang task force, assigned to the Rampart Division west of downtown, one of the most densely populated areas in Los Angeles, with a primarily Latino population and a documented gang presence. Crash officers were given wide discretion and minimal supervision. The unit had developed a culture entirely its own. Membership required a sponsor. New officers were expected to participate in planting evidence as a loyalty test, proof they wouldn't report what they saw. Officers who followed the rules transferred out. Officers who didn't transferred in. They had a logo, a skull wearing a cowboy hat, encircled by poker cards showing the dead man's hand, aces and eights. They wore it as a tattoo. Off-duty, they gathered at a bar near Dodger Stadium to drink and celebrate shootings. Supervisors handed out plaques to officers who wounded or killed suspects. Red card for a wounding, black card for a kill. Rafael Perez joined Crash in 1995. He was valued for his Spanish fluency and his knowledge of local gangs. He was also, by that point, stealing cocaine from the police property room and replacing it with Bisquick. 8 pounds total, street value estimated at approximately $1 million. Crash officer David Mack, another member of the Circle, robbed a Bank of America branch in November 1997, taking $722,000. Several Crash officers were simultaneously working off-duty security for Death Row Records, the rap label run by Marion Suge Knight. The unit was not a police division that had gone sideways. It was an organization operating by its own rules, inside a police department that had stopped looking. In August 1998, investigators auditing the LAPD property room discovered that cocaine was missing. Within days, they focused on Perez. He was arrested on August 25, 1998. His first trial ended in a mistrial. Jury deadlocked. Facing a second trial and the possibility that his wife could also face charges, Perez negotiated. He would plead guilty to cocaine theft. He would receive no more than 5 years. In return, he would cooperate fully with investigators. He started with Javier Ovando. Over 9 months, Perez sat with investigators and described, in documented testimony, what had happened on October 12, 1996. He and Durden had encountered Ovando in the hallway. Durden fired. Perez fired. Ovando went down. There was no gun on him. Durden left the apartment, returned with a red rag, and let the Tech 22 fall from it near Ovando's body. The weapon had been recovered in a prior operation. Durden had kept it. The serial numbers had been filed off before that night. Records confirmed it. The Tech 22 was logged as recovered in a prior sweep, with no chain of custody connecting it to Ovando. The medical evidence, the wound trajectory, and Ovando's physical condition was inconsistent with the officer's trial testimony that he had been charging at them when shot. On September 16, 1999, Javier Ovando was released from prison. The district attorney's office filed a writ of habeas corpus overturning his conviction. It was, at that point, the first time in Los Angeles history that the DA had moved to free someone already convicted at trial. Ovando had been in prison for 3 years, paralyzed, for a crime that the officers who shot him invented in the time it took Durden to walk down the hallway and come back with a rag. Durden was arrested in July 2000. He was charged with attempted murder, perjury, and filing false police reports. He pleaded guilty to 1 count of conspiracy to violate Ovando's civil rights and was sentenced to federal prison. Perez received his 5-year state sentence and an additional 2 years federal for his role in the conspiracy against Ovando. Over 9 months of cooperation, Perez implicated more than 70 officers. More than 100 convictions were ultimately overturned. The city of Los Angeles faced over 140 lawsuits. Settlements exceeded $125 million. The LAPD operated under a federal consent decree and years of court oversight. Ovando received a $15 million settlement, the largest police misconduct judgment in LAPD history at the time. A paralyzed man spent 3 years in a prison wheelchair for a crime that was built in seconds out of a red rag and a stolen gun. The unit ran that way for nearly a decade before one cocaine theft arrest pulled the thread. Number 3, Chicago. A police commander ran a torture operation from the early 1970s through 1991. Electric shocks, plastic bags, loaded weapons placed in suspects' mouths. More than 100 people. The city knew. The supervisors knew. He collected his pension for 17 years after being fired, and then a civil lawsuit put him under oath, and the FBI arrested him for lying. Number 3, Chicago, Area 2 Police Headquarters, South Side, 1982. A suspect is brought in for questioning in connection with the murders of 2 police officers. What happens in that interrogation room, and in dozens of rooms like it across nearly 2 decades, is not recorded in any official log. It is described independently by more than 100 people who never compared notes. Electric shock applied to the ears and genitals. Plastic bags pulled over the head until the suspect loses consciousness. A loaded gun placed in the mouth. A phone book used as a buffer so the bruises don't show. These are the techniques. The man running the operation is Commander John Burge, decorated Vietnam veteran, rising star of the Chicago Police Department, assigned to the highest crime district in the city. What the suspects who survived those rooms couldn't have known was that their complaints were going to the same department that employed Burge. And for 20 years, that department did nothing. Burge joined the CPD after serving as a military police investigator in Vietnam. He was promoted quickly. By the early 1970s, he was running interrogations at Area 2 on Chicago's South Side, and he had built a crew around him, a core group of white detectives who operated as a unit, shared the same methods, and understood what was expected of them. The techniques they used were not improvised. They were consistent. They were repeated. They were, according to later documentation, celebrated. The targets were almost exclusively black men. Some were guilty of serious crimes. Many were not. What they shared was vulnerability. Criminal records that made their complaints easy to dismiss. Neighborhoods where their word carried no weight against the detectives, and a criminal justice system that needed convictions and wasn't asking how they were obtained. The electric shock device, referred to internally as the box, was used repeatedly at both Area 2 and later Area 3. Suspects described the same instrument, the same procedure, the same officers, across cases spanning nearly 20 years. Plastic typewriter bags were used for suffocation. Suspects were beaten with phone books, specifically because the books distributed impact without leaving visible marks. In at least some cases, a gun was placed in a suspect's mouth, and the trigger pulled on an empty chamber as a threat. Complaints were filed. Internal Affairs received them. The 1990 Goldston Report, an internal CPD document, listed 50 confirmed instances of abuse by Burge and officers under his command. The report was buried. It did not result in charges. It did not result in a serious departmental investigation. Burge continued working. In 1989, Andrew Wilson, one of Burge's early victims convicted of killing 2 CPD officers, won a civil trial that exposed the pattern publicly for the first time. A fellow CPD officer testified that what was happening at Area 2 was an open secret inside the department. The city of Chicago formally acknowledged in 1991 that Burge had tortured Wilson. In 1993, the Chicago Police Board voted to fire him. He immediately began collecting his full pension. No criminal charges were filed. The city's position was that it had handled the matter administratively. Burge moved to Apollo Beach, Florida. He drew his pension every month. Back in Chicago, the men whose confessions he had extracted, some of them on death row, were still waiting. Special prosecutors were appointed in 2002 to investigate. Their 4-year review confirmed that the crimes had occurred. It also concluded that the statute of limitations on the underlying torture charges had expired. There would be no prosecution for what Burge had actually done. What the statute of limitations could not protect against was what Burge did next. In 2003, Madison Hobley, one of 4 death row inmates pardoned by Illinois Governor George Ryan, whose convictions were based entirely on Burge-era confessions, filed a federal civil rights lawsuit. Burge was required to give sworn testimony. Under oath, in a formal deposition, he denied ever torturing anyone. He denied ever witnessing torture. He denied that any of it had happened. Investigators already had the Goldston report. They had Andrew Wilson's medical records, which documented injuries consistent with electric shock. They had the testimony of 118 people, documented independently, describing identical techniques with a consistency that could not be coincidental. And they had Burge's sworn denial, on record, directly contradicting all of it. In October 2008, U.S. Attorney Patrick Fitzgerald charged Burge with 2 counts of obstruction of justice and 1 count of perjury. On October 21, 2008, FBI agents drove to Apollo Beach, Florida, and arrested him at his home. The charges were not for torture. The statute of limitations had seen to that. The charges were for lying about it, for swearing. Under oath that none of it happened, when 15 years of documented evidence proved otherwise. Fitzgerald was clear at the time. The sentence was for perjury, but the record being entered was about everything. On June 28, 2010, Burge was convicted on all 3 counts. On January 21, 2011, Judge Joan Humphrey Lefkow sentenced him to 4.5 years in federal prison, twice the amount recommended by federal probation guidelines. She made a lengthy statement at sentencing. Burge was released on October 3, 2014. He died on September 19, 2018. More than 20 of his victims were eventually exonerated. Dozens more were released. In 2015, the Chicago City Council passed a reparations ordinance, a $5.5 million fund for Burge torture survivors, making Chicago the first city in the United States to pay reparations specifically for police torture. The city had paid more than $57 million in Burge-linked settlements by that point, against a broader backdrop of over $521 million in CPD misconduct costs across a single decade. He tortured over 100 people, walked free for 17 years after being fired, collected his pension while his victims sat in cells. The federal charge was perjury, but the courtroom record said everything else. Number 4, Chicago, Bronzeville Neighborhood, 2004. Sergeant Ronald Watts and his team pull up to the Ida B. Wells housing development in uniform. They are the law in this complex. Everybody knows it. A resident has refused to pay. Within 48 hours, that resident is in handcuffs. Drugs were found on him, according to the police report. The report is signed. The charges stick. The conviction goes on the record. This happens again, then again after that. What the residents of Ida B. Wells couldn't prove, though many of them knew, was that the drugs in those reports didn't exist until Watts's unit put them there, that the money changing hands before the arrests was going in the wrong direction, that the sergeant assigned to protect their building was operating a taxation scheme, and the penalty for non-payment was a felony conviction. Watts was assigned to police the Ida B. Wells development in Bronzeville, one of Chicago's historic public housing complexes, and he ran his unit there with near total autonomy from roughly 2003 through 2012. The scheme was straightforward. Residents and local drug dealers paid Watts a regular cut, cash, in exchange for being left alone. Refusal to pay meant planted drugs, a falsified police report, coordinated false testimony from multiple officers in court, and a conviction that would follow the target for the rest of their life. The unit didn't just fabricate charges occasionally. They fabricated them systematically across hundreds of cases over nearly a decade. Multiple officers under Watts's command signed false reports. Multiple officers testified in court to witnessing criminal conduct they had not witnessed. In some cases, a later review by investigators found that the officers were physically documented as being in 2 separate locations at the same time. Their own paperwork proved they couldn't have seen what they swore they saw. The FBI opened an investigation into Watts in 2005. They closed it in 2006 for lack of sufficient evidence. They reopened it in 2007 after receiving information from other Chicago police officers. What investigators didn't fully account for at that stage was how confident Watts had become. He had been investigated, and nothing had happened. He kept going. By 2011, the FBI was ready to move. They constructed an undercover sting operation built around a federal informant, a man who approached Watts's unit presenting himself as a homeless drug courier, carrying cash for a trafficking organization. The setup was designed to do one thing: put Watts on record in real time, taking money he knew was dirty. In November 2011, the informant made contact with the unit. Officer Khalat Mohammed, working under Watts, took $5,200 in cash from the informant. Approximately 45 minutes later, Watts himself met with the informant to pay out hundreds of dollars for his cooperation in the transaction. That meeting was captured on surveillance video. The conversation was recorded through a wire on the informant. The cell phone records documenting the calls between Watts and the informant before the meeting were preserved. On that recording, Watts told the informant, "Never doubt, brother, who always takes care of you." It was the kind of statement that assumed total safety, the kind a man makes when he believes no one is listening. What Watts didn't account for was that every dollar, every word, and every phone call had been logged before he said it. Watts and Mohammed were arrested in February 2012. Both pleaded guilty. In 2013, Watts was sentenced to 22 months in federal prison. Mohammed received 18 months. Watts was released in 2015 and relocated to Las Vegas, where he kept a low profile and said nothing publicly as the consequences of his operation began to unfold back in Chicago. Because the arrests were only the beginning. Starting in December 2016, Cook County State's Attorney Kim Foxx's office began systematically reviewing convictions tied to Watts and the officers under his command. What they found, case after case, was the same pattern. Reports that couldn't be true, testimony that contradicted physical reality, charges built entirely on the word of officers who had already been convicted of stealing from a federal informant. The convictions started coming down, then more after that. A later review by the Civilian Office of Police Accountability confirmed what the exonerees had been saying for years. That in documented cases, officers had claimed under oath to observe criminal conduct from positions where it was physically impossible for them to have seen what they described. One officer, according to COPA findings, was on record placing himself in 2 different locations simultaneously in separate sworn statements. By 2022, the final batch of Watts-linked convictions had been vacated. The total, per Cook County Court records, reached 212 cases, dismissed. 226 per a separate tally maintained by WBEZ based on court proceedings. It was the largest mass exoneration in Chicago history. The victims had served a combined total of more than 274 years in prison. In September 2025, the city of Chicago approved a $90 million global settlement covering 176 civil rights lawsuits connected to Watts and his unit, resolving cases involving 180 people who had spent a combined nearly 200 years behind bars. Adding prior settlements and legal defense costs, the total financial exposure to the city reached $126.8 million. An alderman noted during the Finance Committee vote that it was, in his assessment, almost certain the city would have lost every single lawsuit if they had gone to trial. Judges had already determined, across case after case, that the plaintiffs were innocent. 212 people. 274 years of combined prison time, 1 housing project, 1 sergeant. The FBI got him on $5,200 from a man pretending to be a homeless courier. And that was enough to bring the entire structure down. Number 5. New Orleans. A cop known in the projects as RoboCop is running cocaine and protecting dealers. The FBI has already wired his operation, and then a woman files a police brutality complaint, and he orders her killed before sundown. Number 5. New Orleans, October 10th, 1994. A teenager is being pistol whipped in the lower 9th Ward by a police officer who has mistaken him for a shooting suspect. A 32-year-old woman named Kim Groves is watching from nearby. She knows what she saw. That same day, she walks into the New Orleans Police Department and files a formal brutality complaint with Internal Affairs. She names the officer. She puts it in writing. What Kim Groves doesn't know is that the officer's partner, the man who will be informed about her complaint before the day is over, is already under FBI surveillance for running a cocaine distribution ring out of his patrol district, and that within 72 hours, she will be dead. Officer Len Davis worked the 5th District of the New Orleans Police Department. In the Desire Housing Development, where he patrolled, he was known by 2 names, RoboCop for his aggression, and the Desire Terrorist for what happened when someone crossed him. By December 1993, Davis and his partner Sammy Williams had begun extorting bribes from drug dealers in the district. Protection money, paid in exchange for police cover. What they didn't know was that one of those dealers was a federal informant. The FBI launched an undercover operation. It was elaborate and dangerous. Real cocaine was used. Marked money, $97,000 of it, was distributed to officers in payments. Davis and Williams recruited 7 more officers into the scheme. At times, these officers guarded drug shipments while on duty, in uniform, in marked patrol vehicles. The FBI assigned more than 60 federal agents to the operation and conducted it in total secrecy. It ran for nearly a year. By September 1994, the operation had hit a critical point. Intercepted conversations indicated that Davis and other officers were discussing robbing the undercover couriers and committing violence against the primary undercover agent. The FBI significantly increased security for its personnel. The sting was still running when Kim Groves filed her complaint on October 10th. Davis was tipped off about the complaint the same day it was filed, by another officer inside the department. He knew who had filed it. He knew where she lived. And he knew that a brutality complaint, if it gained traction, could expose the operation he had been running for nearly a year. He called Paul Hardy. Hardy was a local drug dealer who had been part of the protection arrangement, one of the people Davis had been providing cover in exchange for cash. The call was captured by the FBI wiretap already running on Davis's communications. In that call, Davis told Hardy he could arrange for Hardy to come handle the woman who had filed the complaint, and that Davis would then manage the police report, make sure nothing connected back to either of them. The translation, as Davis's partner Williams later explained to the jury, Hardy would kill Kim Groves. Davis would write the report that buried it. On the evening of October 13th, Hardy was driven to the neighborhood where Groves lived. Davis monitored the situation from his patrol car using the police radio. At 10:50 that night, Davis received confirmation over the radio that Groves had been shot. Witnesses later testified that Davis began jumping up and down in his cruiser. The words he used, recorded on the FBI wiretap, referenced a film in which an assassin said a particular phrase each time she completed a kill. Davis used the same phrase. He was, by every documented account, celebrating. On October 14th, 1994, Kim Groves was shot and killed outside her home on Alabo Street. She was 32 years old. She had 3 children. The FBI immediately shut down the undercover drug operation. The decision was made to end the sting in order to protect the safety of the undercover agents, whose cover could no longer be guaranteed given the violence Davis had already demonstrated he was willing to use. The drug trafficking case was terminated early, but every conversation, every transaction, and the murder order itself were already on tape. Davis was arrested and charged with directing the killing of Kim Groves, along with the drug conspiracy charges that had been building throughout the sting. The federal charges were filed under civil rights statutes. Because Davis had used his official position as a police officer to orchestrate the murder, he was prosecuted federally for depriving Groves of her constitutional rights through killing. The trial opened in April 1996. The prosecution's case was built primarily around the wiretap recordings and the testimony of Sammy Williams, Davis's partner, who had been indicted separately and agreed to cooperate. Williams told the jury what the coded language in the recorded calls meant, that Handle the 30 was police radio code, that NAT stood for necessary action taken, that Davis had laid out the plan for the murder in terms his partner understood immediately. Williams also testified that on the day Groves was killed, he and Davis had split $16,000 in cash from the drug operation. Steve Jackson, who had driven Hardy to the neighborhood that night, also testified under a cooperation agreement. He described Hardy's words in the car on the way there, and Hardy getting out, and Hardy running back telling him to drive. On April 24, 1996, the jury convicted Len Davis. He was sentenced to death on April 26, 1996, the first on-duty police officer in United States history to receive a federal death sentence for civil rights violations. His sentence was overturned on appeal in 1999. A jury resentenced him to death in 2005. In December 2024, President Joe Biden commuted Davis's sentence to life in prison without possibility of parole as part of a broader federal death row commutation. Davis filed a handwritten motion attempting to block the commutation. It was rejected. In 2022, 3 men Davis had falsely testified against, framed for a 1994 murder he is now believed to have been connected to himself, were released from prison after serving a combined 28 years. A 4th man connected to separate Davis testimony was released the same year after 32 years. The city of New Orleans settled with Kim Groves' 3 children in 2018 for $1.5 million. He ordered the execution of a witness while standing in a police uniform and celebrated over the radio when it was confirmed. The only reason Kim Groves' children ever learned the truth was that the FBI was already listening for something else entirely. Number 6, Miami, 1985. 3 bodies float up in the river near a boatyard. The weapons recovered nearby are police-issued. The officers who respond to investigate are connected to the same operation as the men in the water. And what unfolds over the next 3 years is the largest uniformed drug conspiracy in American policing history up to that point. Number 6, Miami, July 28, 1985. 3 bodies are found floating in the Miami River, near a commercial boatyard known as the Jones Boatyard. The initial call goes out as a possible drowning. Investigators arrive and find something different. All 3 men have been shot. The weapons recovered in the vicinity are police-issued firearms. The bodies belong to drug couriers who had been moving a cocaine shipment by boat along the river that night. What looks, at first, like a drug deal gone wrong is something more specific than that. The deal didn't go wrong because of the drugs. It went wrong because the officers who showed up to rob the shipment killed the people guarding it, and then had to figure out what to do with the bodies. One of the officers connected to that operation was already on the radar of Metro-Dade detective Alex Alvarez, who had been quietly running a covert recording sting targeting a group of Miami Police Department officers he suspected of operating well outside their authority. What Alvarez was building a case around, and what the Jones Boatyard murders confirmed, was that a significant portion of the Miami PD had organized itself into something investigators would later call the Enterprise, a structured criminal ring operating inside the department since 1984 that had moved from street-level theft to large-scale cocaine robbery and resale. It started small, the way these things often do. In 1984, a group of officers began targeting drug dealers stopped for routine traffic violations. They would conduct searches, find cash or narcotics, and simply take it, logging nothing, splitting the proceeds. The dealers had no recourse. Filing a complaint about stolen drug money meant admitting you had drug money. The officers understood this and counted on it. What they didn't account for early on was that the operation would grow past the point where that logic protected them. By 1985, the group had graduated from roadside theft to something far more organized. They had identified the Miami River as a corridor for cocaine shipments moving by boat, and they began planning and executing armed robberies of those shipments at the docks. The ring included officers from multiple units. Key figures identified in the eventual investigation included Armando Estrada, Rodolfo Arias, Osvaldo Coelho, and Armando Garcia, among others. 19 officers in total would eventually be convicted. The cocaine they seized was mostly resold. Some was kept for personal use. The Jones Boat Yard was supposed to be another robbery. Officers arrived to take the shipment. Something went wrong during the confrontation. The exact sequence of events was disputed at trial. And 3 couriers ended up in the river. The weapons left at the scene were traced back to the department. The bullet trajectories and physical evidence at the yard were inconsistent with a spontaneous drug dispute. Investigators began looking at who had been in that area that night, and the names that came back wore badges. Detective Alvarez's covert recording operation was already in motion. Over the following months, his sting captured several officers on tape attempting to sell cocaine to undercover agents. Cocaine that had been stolen from shipments in exactly the manner investigators suspected. The FBI joined the investigation, broadening the financial analysis and building a racketeering case that could hold the entire structure together. The first trial opened in September 1986. 7 officers, including Estrada, Arias, and Rodriguez, were seated as defendants, the jury deadlocked. A mistrial was declared. Prosecutors regrouped. Then Rodolfo Arias made a decision. Arias agreed to cooperate with the prosecution and testify against the other officers. What he provided was a detailed first-hand account of how the ring operated, who was involved, how the robberies were planned, how the cocaine was divided and resold. He testified that he alone had made at least $1.08 million reselling drugs stolen from smugglers during the ring's operation. He also admitted to having received 4 kilograms of cocaine as a gift from officers involved in the Jones Boat Yard incident, which he then sold for $92,000. His cooperation, combined with the physical evidence from the boatyard and Alvarez's undercover recordings, gave prosecutors what the first trial had lacked: a witness who could explain from inside exactly what the jury was looking at. 20 officers were indicted in the second round of proceedings. 10 pleaded guilty. 2 were convicted at trial in February 1988. The convictions covered charges including murder, racketeering, robbery, drug trafficking, civil rights violations, and conspiracy. Armando Garcia fled before he could be taken into custody. He made his way to Cali, Colombia. In January 1994, he was added to the FBI 10 Most Wanted Fugitives list. Entry number 423. A tip to the television program, America's Most Wanted, led Colombian security police to him. He was stopped as he drove away from his apartment in Cali alongside his father. He attempted to bribe the officers who detained him. It didn't work. He was extradited to the United States, prosecuted, and sentenced. Prison records indicate he was released in 2006. Arias, despite his cooperation, was not without his own legal exposure. In addition to the drug charges, he was charged with conspiracy to commit murder. He had allegedly conspired with Coelho to kill a local bar owner who had helped facilitate the officers' early entry into the drug trade and was considered a liability. He received a reduced sentence in exchange for his testimony. In total, nearly 100 officers were arrested, fired, suspended, or formally reprimanded across the full scope of the investigation. The ring had operated for over a year in plain sight, inside one of the country's most active police departments, in one of the most drug-saturated cities in the United States at the height of the cocaine era. It fell apart because one officer decided the deal being offered by prosecutors was better than the one he had made with the people he worked with. Number 7. Antioch, California, 2023. An elite plainclothes unit has been beating suspects and writing false police reports to cover it. They have been enrolling in college courses that don't exist to collect pay raises the department never authorized. And they have been doing all of it while leaving a text message trail that documents, in their own words, exactly what they were doing and why. The FBI serves warrants in 3 states on the same morning. Number 7. Antioch, California, August 17th, 2023. It is early morning when arrest warrants are served simultaneously across 3 states, California, Texas, and Hawaii. 10 current and former police officers from 2 Bay Area departments are taken into federal custody on the same day. The FBI's San Francisco field office has been building this case for 2 years. When the indictments are unsealed, the charges run from civil rights violations to wire fraud to obstruction of a federal investigation. The case started with complaints. It ended with text messages that made the complaints look conservative. The officers came from the Antioch Police Department and the neighboring Pittsburgh Police Department, 2 mid-sized departments in Contra Costa County east of San Francisco. The lead defendant was Morteza Amiri of the Antioch PD. The charges against him were among the most extensive in the indictment: conspiracy against rights, multiple counts of deprivation of rights under color of law, destruction, and falsification of records in a federal investigation, and wire fraud. 9 other current and former officers faced varying combinations of the same categories. To understand what the FBI found, you have to understand the 2 separate schemes running simultaneously inside these departments, because what made this case unusual was not just the violence, but the paperwork built around it, and then the separate fraud built on top of that. The first scheme was the one that drew initial attention. Over a period spanning roughly 2018 through 2022, officers used excessive force against suspects during arrests and encounters. That part, on its own, generates complaints regularly in departments across the country. What elevated this to a federal case was what happened immediately afterward, every time. The officers authored police reports describing each incident in detail. Reports that characterized the force used as necessary, justified, and lawful. The indictment quoted the specific language those reports used and then documented how that language directly contradicted the physical evidence, the injuries, and, critically, the officers' own private communications. Because while the official reports described measured, proportionate responses, the text message threads told a different story entirely. The officers had been communicating through group text threads that investigators obtained during the FBI's wiretap investigation. Those threads documented the officers' actual mindset before, during, and after the incidents in question. They included racist language. They referenced specific individuals and specific encounters. They showed coordination. The gap between what the officers wrote in their official reports and what they wrote to each other in those messages was not ambiguous. The indictment stated directly that the defendants authored reports containing false and misleading statements designed to make unlawful force appear justifiable, and that they knew at the time of writing that the statements were false. That alone would have been a significant federal civil rights case. But the investigation had also uncovered something separate, a fraud scheme that, in its own way, revealed how comfortable the officers had become operating without consequences. 6 of the officers, including Amiri, were charged with conspiracy to commit wire fraud in connection with a scheme involving educational pay incentives. The Antioch Police Department, like many departments, offered pay raises to officers who completed college coursework, an incentive designed to encourage professional development. The officers charged in this scheme had submitted documentation claiming enrollment in college courses. The courses, investigators confirmed through university records, were fabricated. The officers had not attended them. The paperwork was false. The pay raises were collected anyway. It was a separate crime from the civil rights violations built on the same foundational assumption that no one was checking. What they didn't account for was that the FBI had already been inside their communications for 2 years before the warrants were served. A separate charge in the indictment targeted Officer Timothy Manley Williams, who was not accused of the force or fraud schemes but faced his own federal exposure. In 2021, Williams used a personal cell phone to make a call to an individual who was the target of an active FBI wiretap investigation. He warned that person. He then failed to log the call in any official record, ensuring it wouldn't appear in department communications. The FBI had been monitoring the wiretap target at the time. Cell phone records confirmed which device Williams used when the call was made, and that it was deliberately kept off the official log. Williams was charged with obstruction of a federal investigation. On August 17, 2023, when the indictments were unsealed and the warrants were executed, one of the defendants, Eric Allen Rombo, appeared in Oakland federal court dressed in ripped clothing with bloody hands and knees. His attorney told the judge there was no reason his client needed to be taken into custody at all, that he would have appeared voluntarily. The physical condition Rombo arrived in was not explained in court. The charges across all defendants carried potential sentences of decades in federal prison. U.S. Attorney Ismail Ramsey, announcing the indictments, stated that any breach of the public's trust was absolutely unacceptable. Robert Tripp, the FBI's special agent in charge of the San Francisco field office, was direct. The investigation was the result of 2 years of work, and the arrests were the consequence of officers who had used their official positions to deprive people of their rights. The federal proceedings were ongoing as of the indictment date. The defendants faced trial on the full range of charges, what the text messages established. And what made this case harder to defend than most was that the officers had documented their own intent. The police reports said one thing, the text threads said another. Investigators didn't have to argue about what the officers were thinking. The officers had written it down, text messages, fake college transcripts, falsified use of force reports authored while the real account of each incident existed in a group chat on someone's phone. The paper trail they left behind was longer than any criminal record they had manufactured. Number 8, Mississippi Delta, October 2025. Not one department, not one county, 5 counties. Sheriffs, deputies, police chiefs, and patrol officers, all on the same alternative payroll, all escorting the same shipments, all taking the same cash. The FBI built a fake drug convoy, drove it through the Delta, and watched to see who showed up in uniform to protect it. Number 8, Mississippi Delta, October 30th, 2025. Before sunrise, FBI SWAT teams and hostage rescue personnel, drawn from multiple states and coordinated through the Bureau's Jackson field office, fan out across 5 counties simultaneously: Washington, Humphreys, Bolivar, Sunflower, LaFleur. The warrants are served at the same moment across all of them, because the investigation has determined that giving any one target advance warning would alert the others. In a region where law enforcement and criminal infrastructure have been sharing the same payroll, that risk is not theoretical. By the time the operation is complete, 14 current and former law enforcement officers are in custody, among them sheriffs, deputies, police chiefs, and patrol officers. 6 civilian co-conspirators are charged alongside them. FBI Deputy Director Andrew Bailey, speaking at the press conference, describes the corruption as having permeated all levels extending across multiple counties and multiple jurisdictions. U.S. Attorney Clay Joyner calls it a monumental betrayal of public trust. The investigation that produced those arrests did not begin with the FBI. It began with drug dealers. Specifically, it began when individuals arrested on drug charges started telling investigators something consistent and specific, that they had been paying protection money to the same law enforcement officers who were supposed to be arresting them. The complaints were coming from multiple counties. The officers being named held different ranks, worked for different departments, operated in different jurisdictions. But the arrangement they described was identical. Cash paid regularly in exchange for the officers looking away from drug shipments moving through the Delta. The FBI Jackson field office began building a case. Confidential informants with direct knowledge of the bribe arrangements were developed. Financial records were pulled. Wiretaps captured pre-operational planning. Conversations between officers and their contacts in the drug trade. What investigators assembled over a multi-year investigation was a picture of corruption that did not fit the model of a few rogue officers in a single department. It fit the model of a regional system, one that had been operating long enough and openly enough that the people paying into it treated it as a cost of doing business. Washington County Sheriff Milton Gaston was among those charged. His county included the town of Leland, population approximately 3,000, where a mass shooting had killed 6 people and wounded more than a dozen others during homecoming celebrations just weeks before the arrests. The timing was not lost on the investigators or the prosecutors. The sheriff with jurisdiction over that community, at the moment his county was processing a mass casualty event, was simultaneously under federal investigation for accepting bribes to facilitate drug trafficking. The mechanism that finally captured the evidence needed for prosecution was a controlled sting operation, designed and executed by the FBI with the precision the multi-county scope required. The Bureau staged a drug convoy. 55 pounds of cocaine, not real, was loaded for transport. Briefcases of drug money were prepared, also not real in terms of the underlying transaction, but real enough in appearance to complete the scenario. The cash bribes paid to the officers during the operation were real, marked, tracked by serial number from the moment they left federal hands. Officers in marked law enforcement vehicles, wearing uniforms, were observed and documented escorting what they understood to be a live drug shipment moving through their jurisdictions. Some of them accepted more than $30,000 in individual bribe payments during the controlled operation. The surveillance of the convoy escort was documented. The recorded communications between officers and their contacts in the operation were preserved. The financial records connecting the marked cash to specific individuals were locked in. What the defendants could not explain when the warrants arrived was why their fingerprints and documented movements placed them alongside a drug convoy they had no legitimate reason to be near, or why the serial numbers on the cash in their possession matched bills that had left the FBI's evidence room. Bailey's statement at the press conference was direct. He described 14 current and former law enforcement officers who had sold out the public, promoted the very crimes they were sworn to investigate, and taken bribes to facilitate the distribution of controlled substances rather than stop it. He said the corruption had disgraced the badge and undermined the work of every honest officer in the state and the region. He closed with a warning aimed specifically at officers in positions of public trust. The FBI would not allow the wrongdoing to go unanswered, and for those who abused their office, the Bureau would come for them. Joyner, for his part, was focused on accountability. He told reporters that what the public needed to see, what all of them would want to see, was consequences. The investigation, he noted, was ongoing. The 14 arrests were described as a first step, not a final one. All defendants were granted bond as of the arrest date. Federal proceedings were underway. The charges included conspiracy to distribute controlled substances, bribery, and use of official position to facilitate drug trafficking. The case was described by federal authorities as one of the largest public corruption investigations in Mississippi's recent history. 8 cases, 8 different cities, departments, eras, and structures. Baltimore, Los Angeles, Chicago twice over, New Orleans, Miami, the Bay Area, and the Mississippi Delta. Task forces and commanders and sergeants and patrol officers, electric shocks and planted guns and wiretapped murder. Orders and fake college transcripts and marked bribe money in a staged convoy. What connects them is not the method. The methods varied. What connects them is the assumption held by every officer in every one of these cases that the badge made them invisible, that the complaints would go nowhere, that the internal review would clear them, that the statute of limitations would run out, that nobody was listening. In every case, something was already running before they realized it. A wiretap, an informant, a civil lawsuit, a federal sting, a DEA intercept meant for someone else entirely. 14 badges, 5 counties, a fake cocaine shipment, and real cash. The FBI drove the convoy, and the officers lined up to escort it.